The next case to come before the court is State versus Arcuri. Thank you, everyone. Good morning.
Good morning.
First of all, I'd like to thank all the attorneys and parties for attending here today and making this possible so that we could have our courtroom in the Elyria High School with all these wonderful students. So thank you so much. Each side will have 15 minutes to run their arguments, and the appellant may reserve up to 5 minutes. And I will be keeping time, so I'll try to tell you when you're getting into your rebuttal time, and when you're ready to proceed, we'll review it.
Good morning. Good morning, Your Honors. May it please the court, my name is John Forstall, and I represent the appellant, Mr. Aaron Arcuri. I'd like to reserve 5 minutes for rebuttal. There are 3 assignments of error in this case, 2 having to do with Mr. Arcuri's constitutional right to retain counsel under the 6th Amendment and the 14th Amendment of the U.S. Constitution. The 3rd assignment concerns manifest weight. Mr. Arcuri represented himself in a bench trial in the Medina Municipal Court. He was charged with driving under a license suspension for an OVI that carried a mandatory 3-day jail sentence after he was convicted. He also had a traffic violation, a minor misdemeanor marked claims violation. He represented himself. He claimed to have driving privileges. He was convicted, and as a result of that conviction, he was sentenced to the mandatory 3 days in jail. After that, he retained counsel and tried to get the decision reversed. Was not successful, and that's how we ended up here today. The ultimate issue on the first 2 assignments regarding the right to counsel: did Mr. Arcuri at the trial court on the day of the bench trial make a knowing, intelligent, and voluntary waiver of his right? And obviously, as this court is aware, it's a de novo totality of the circumstances review. The seminal case in this area is the Van Moltke v. Gillies case, U.S. Supreme Court case 1948. It says a valid waiver of right to counsel must be made with an apprehension of the nature of the charges, range of possible punishments, possible offenses, mitigation, and other factors essential to a broad understanding of the whole matter. That's really the crux of the appeal, whether or not the trial court explained the other factors essential to a broad understanding. And some of those that the Van Moltke talked about way back in 1948 were taken into account the defendant's age, education, and legal experience. And as far as this pro se bench trial for Mr. Arcuri, on the day of the bench trial, the court did explain some of the dangers of him proceeding as his own attorney, but the court did not talk anything about possible defenses.
Didn't the court talk about that during the arraignment? Shouldn't we read this together with all the proceedings?
I don't believe so, because that was weeks earlier, first of all, Your Honor, and he didn't waive counsel at the arraignment. And the important interaction is what happens when he's actually there on the trial trying to represent himself, especially in light of a mandatory jail sentence. And so there's no, I don't think there were any discussions at the arraignment. Even if they were, it's irrelevant. They needed to revisit it to make sure that there was a broad understanding of the whole matter for Van Moltke. And also there was no discussion of Not that I recall, Your Honor, possibly at the arraignment, but in our estimation, that's irrelevant to what happened at the bench trial. But in addition to that, there's no discussion at any point to explain to him that he has the right to an appointed counsel. There was no inquiry about whether or not he was eligible for appointed counsel.
What does that say about the arraignment?
There was no discussion. They didn't ask, what's your income? Are you able to get an attorney? And then there's a 9th District case that talks about when there's a mandatory jail sentence, even if a defendant can afford an attorney, the court should still appoint an attorney if there's mandatory jail. And that case is cited in the brief. It's the Henry case, 9th District 2000 case. It says, even if, for whatever reason, appointed counsel must be provided, or no sentence or incarceration will be imposed. So the optimum issue in this case is, was there a knowing and intelligent waiver? And as far as what was done at the arraignment, it still doesn't meet the Van Moltke requirements at arraignment. And it also, if you put it all together with what was done at the trial court, they still don't meet the Van Moltke. There's nothing in the record about his education level. There's nothing in the record about his legal experience.
Doesn't the defendant have a right to represent himself if he wants to?
Yes.
And the question by the court seems to be, do you want to be a lawyer?
Right, but that's not sufficient. And that's what Van Moltke says. You have to have, they have to make sure that Mr. Arcuri had a broad understanding of the whole matter. And just giving blanket statements like, look, you understand that you want to be your own lawyer or you don't want to be your own lawyer. There's no broad understanding.
The trial judge said before that, you have the right to have an attorney, and if you can't afford an attorney, the court can appoint you an attorney at no cost. And then his next question is, do you want a lawyer? That sounds like it's a preference.
Right, but that's not a broad understanding of the whole matter. During that discussion, they didn't inform him that there's a mandatory 3-day jail sentence on the OBI driving under suspension. And that's a huge distinction in this case.
But
And
the judge did say that at the arraignment.
briefly, but there's no discussion. The issue is there a discussion? Is there a broad understanding? And just, when you have we don't know how sophisticated Mr. Arcuri was, because again, there's no discussion of his education level and of his legal experience. So if we're reading a transcript clean as trained lawyers, we would see those. We might see those words. But does that mean those words actually register without an actual discussion? Just mentioning that, this carries with it $1,000 max fine, possible 180 days in jail, and 3 days in jail. I mean, that's generally how it goes in the court. Is that sufficient for a constitutional violation to make clear and to show that the trial court actually informed him and had a broad understanding of what he was doing and what he was facing? So if there was some back and forth between the court and Mr. Arcuri, we would feel much more comfortable that he actually had a knowing and intelligent waiver. There was no back and forth. It was just very quick, leading questions or yes and no questions. Do you understand? Do you understand this? Yes. Do you understand that? Yes. But again, the record is completely silent on his education level, on his legal experience. And there's a good indication that he had no legal experience. And it's cited in brief from the trial, page 45 of the May 15 transcript. So the judge found him guilty, and Mr. Arcuri didn't even realize the judge found him guilty, and Mr. Arcuri wanted to still present more evidence. He said, take a moment, Your Honor, it's an audible earlier, and he says, am I too late to? And then the court interrupts, yes, I just entered a judgment in the case. We finished the trial, you waive counsel. That little discussion there, it shows that Mr. Arcuri didn't have an understanding. He wasn't knowledgeable, and it wasn't known. And maybe if we knew his education level, or knew his experience, or knew whether or not he actually qualified for an attorney, we'd have a better understanding. And that, to us, testify.
Is it not having privileges, the actual piece of paper on your person, rather than the suspension alone?
It could be. Of course, the trial court didn't explain that to Mr. Arcuri as part of his defenses or possible mitigation. But he can, as part of, if he had an attorney who goes to a pretrial, a lot of times you'd be able to get this charge reduced if you show he actually did have the privileges. So he went to Korea, got another copy of the privileges, and he actually had something corrected as a testified. I had to get something corrected. And those privileges had a start date of March 30th, which was of 2023, which is before the date he got the ticket, which was April 14th. But the timestamp on those privileges was April 17th, because that's the date he went back to the court to get the new privileges because he lost his original privileges. So that alone shows that he had privileges. And so the charge should not have been a driving suspension. He could have gotten no operator's license charge. It's no different than not having your driver's license on a person if you have a valid driver's license. And there's nothing in the record.
You're going to go into your rebuttal time. You can continue, I'm just letting you know.
Just briefly, there's nothing in the record to show that he was, what those driving privileges provided for him, that he was driving outside of those driving privileges. The argument was they were time-stamped afterwards, and the trial court could retroactively apply them. There's no case law to show that. And as the Lakewood case I cited in assignment error 3 shows, the Medina trial court had no jurisdiction to say that the Korea court's privileges were not valid. So if there's no more questions, I'll reserve my time.
Thank you.
Good morning, may it please the court. Thank you, everyone, for coming in. Thank you for having me. Mr. Forrestal. My name is Matt Medina. I'm the prosecutor here in this case. Here to respond to issues raised by Mr. Arcuri in his brief. He also submitted a reply brief. I'm going to respond to that as well. It was not timely filed, but it doesn't appear that it's stricken to the record, so I'm going to respond to that as well. Arguments or issues 1 and 2 that deal with what the court should have done, could have done before they let this man proceed without an attorney. This court did everything that they could do. We're in a court that has 16,000 cases.
Well, I'm going to ask you the same question I asked, because I'm not seeing it quoted in the briefs. When does the judge talk about possible defenses?
The judge does not talk about possible defenses.
Isn't that one of the requirements here?
I don't believe so. Our argument is if you rely on the Henley case, which our court does, and it lays out the requirements that the court must go through. In this case, when I say we, my court, more than sufficiently adhered to Henley as they went through this. We initially didn't get a transcript of spends even more time strongly encouraging him to consider a continuance of getting an attorney, discouraging him from proceeding, representing himself, and went through then a month later in even more detail the name of the charge, the penalties. Again, it's the second time he's told you're going to go to jail for 3 days. It's a 3-day mandatory jail sentence. When we asked him if he's aware of these penalties, yes, sir. Now, then
Is there a written waiver of the right to counsel signed?
yeah, they have him sign a
Is it signed in a written or is it signed or does it?
They have him sign that in the presence of the judge at the trial.
At the trial, so there's not one done at written.
Yeah. And because even though at arraignment, they go through that, there are still times where people think better of it before the trial and retain counsel. And even though they say at the time of the arraignment they're going to proceed without, and they've been explaining the consequences and the penalties, they still elect to retain counsel, or they request that an attorney be appointed before the trial. And that can be done. So then we come back to the trial, sometimes they have an attorney, they still don't, and the judge goes through it all again on the record, but also in his presence, he witnesses and sign a written waiver to that effect. And that's what we did in this case. The court, again, as I went through that transcript, when we get to the trial, made it pretty clear that you may be at a disadvantage versus someone that went to law school. You may not have tried a case, the prosecutor may have tried a case, you still want to proceed. Unlike Henley, which in Henley, it's pretty clear, they just went in and there was a little delay in that case because the state's witness was missing. They just jumped right into the trial. The defendant tried to pro se say, well, what about the witnesses in here? What about dismissal? No, it's premature for that. We'll get to it. We'll get to it. They didn't spend any of the time going through this, and there's no evidence in that case that they give it a written waiver. I understand that, but this is a lot different than that.
The judge, when he was addressing the appellant here, did the judge specifically say, in talking to the defendant, that he not only had the right to counsel, but asked him if he could afford one?
I don't know if he asked him that specific question, can you afford them? I don't remember when I
Or
was
did he say you had the right to counsel and you can't afford one will be appointed for you? Was that anything talked about affordability?
I think, I got the coverage quote. I didn't put that in my brief, so I don't have the transcript sitting right here. So I don't remember if he specifically used that.
As a former trial judge doing these type of cases, that was one of the main things that I felt that I had to inquire about, whether somebody realized that if they could not afford an attorney, they could have one appointed for them. If they didn't notify the defendant of that, don't you think that would be a problem?
Except that if they did, and they definitely did it, because I put it in here, they definitely covered it at the arraignment. I don't know if you use that exact same verbiage again when we came to the trial. But Mr. Arcuri was made aware that if he couldn't afford one would be appointed. And in that written waiver, for sure, has that same language as well, which he signed on the day of the trial. Touching briefly on the second, or the third issue, but really the second main issue, which is the manifest weight. So, when someone's charged with driving under suspension, and all the records that are presented show that he was under suspension, there is the potential for the defense to raise an affirmative defense that, hey, wait, I had a driving privilege. Here's my driving privilege that says, yeah, I'm suspended, but I can drive during this time. So, that was not presented, unavailable at the time of the stop. One, for the offense date was not made available at the time of the trial. But let's assume for a second that this defendant had a driving privilege earlier than the one that he brings to the trial. That for whatever reason, there was one in effect on the date of the offense, and we apply for it 3 days after the traffic stop, and he gets 5 days after the traffic stop. That is a corrected or different privilege than the one that was in effect on the day of the offense. If there wasn't. Assuming there was one, how is the trial court to know what the specific terms of that driving privilege are? It's never been presented to law enforcement, never been presented to the court. Certainly, when the defense suggests we have a corrected or different version, I don't think the court can say, well, let's just retroactively assume that these are the terms because the date is back there. You know, the duty was on the defense to prove that there was a driving privilege, which hasn't been done. And secondly, what the terms of those privileges were.
I know this was a bench trial. Did the defendant testify?
Yes.
Did anybody ask him how the driving privileges were corrected?
I believe he testified that the timing and the ability to take family and haul passengers was adjusted. Something to that effect. I don't remember if his work schedule may have changed a little bit too.
Let me ask you how you're in movie court and the judge said yes, you have driving privileges, go back and forth to work, and here are the times and so forth. And they say, thank you very much, Judge. And then they set the matter over for another hearing or trial. Then the individual is pulled over, he doesn't have any documentation. And let's assume he doesn't have any documentation because the court orally granted it, but for whatever reason didn't file it. Okay. If the court then went on and issued an order that gave him driving privileges to cover the time that he was pulled over, saying that was whenever his driving privileges should have been in effect, why is that possible? Or would that be possible?
It would be up to that trier of fact when you present your affirmative defense. That by preponderance of the evidence, that moves the needle, and the trier of court says, okay, you didn't have the paper privilege. You know, I'm used to privileges where they actually generate a piece of paper. Typically, it says you have to carry it with you. We don't have any of that, but under that scenario, they gave an oral privilege and didn't give them a piece of paper to carry. And further, in that case, maybe they didn't notify the DMV either. Typically, the second you get that privilege, they send it to the DMV, and then your status becomes suspended limited privilege. So an officer stops you, it's just suspended, they don't see limited privilege, the person says, now in this case, he claimed that there was a paper, he just couldn't produce it. But in that case, they would say, yeah, he or she just told me by words I could drive, I don't have paper. But then I walked out and said I could. The officer would still cite the driving under suspension, so we're going to have to convince the trier of fact or test it at court. And then at court, the burden would be on, for presenting that defense, that defendant would have to figure out some way, be a transcript from that oral hearing, or like you said, if they can get it reduced to writing, get something certified, and then present that to that trier of fact, and maybe that would carry the weight, maybe it wouldn't.
Well, the reason I'm asking is because one of the issues that the panel is raising is, can one court go behind the other court's judgment of this? In other words, this court said March 30th, you had right privileges, right? Nobody disagree with that.
The entry says retroactively you have the March 30th.
That's what I'm saying. Right. And so, and that was filed, I understand, after it was pulled over, so I understand your argument, but
It was applied for and granted after.
Circling back to the knowing waiver of the right to counsel, was it discussed with the defendant that having privileges and proving that he had privileges was in fact?
No. It does not go through all potential affirmative defenses that I believe.
and back to my point then. So when the judge issued what you consider to be, and you knew because there was no evidence of a fraud,
determine, you've got a new one there. You see that you've got a new one, and again, his testimony was this is a corrected one, there's changes. Without something showing what the terms of the first driving privilege were, how can this court determine that you,
Well, I think the terms are what it was in the new order, right? Because the court says this is retroactive to March 30th, and it doesn't say, you know, these are the new terms. These terms themselves are retroactive to March 30th, and then whether you would be within those terms is another issue, obviously.
so I guess under that argument, however they change the terms would go back retroactively. I could definitely see how a court would say that you're not going to carry your burden with that. You can think of any type of situation like that where they modify an order and they try to retroactively do it. I mean, it's, as you know, can be very, very difficult. The case cited by the appellant from Lakewood, I believe, is again not akin to what we have here. That case was court number 2 just choosing to take a position that the overly broad amount of driving granted in court number 1 wasn't right, not appropriate, not legal. That's not the fact pattern that we have here. We have
Counsel, you are.
okay.
Thank you.
I'm sorry. Thank you.
Mr. Arcuri actually testified on page 33 of the bench trial transcript, which was the May transcript, that he had to have the privileges updated. He used the word updated, not corrected and changed. I did a quick search of the transcript. There's the word, he didn't testify anything about being corrected or changed or any kind of, just updated. And we don't know what that means because he didn't have an attorney and there wasn't any details provided, but generally, a lot of the courts will give you privileges pre-trial, but again, we're just speculating on that.
But again, you do agree that it's a burden.
Yes, and I think what he presented to the court met his burden. He had driving privileges starting March 30th.
But in terms of manifest weight, the judges frequently not believe that next step.
Right, but I mean, it's black and